Here is a detailed, exam-style explanation of dying declaration, its relevancy, and supporting legal principles. Dying declaration, meaning and relevancy. Section 32, Indian Evidence Act, 1872. What is a dying declaration? A dying declaration is a statement made by a person who is on the verge of death about the cause of their death or circumstances leading to it. Definition, Sec. 32.1, IEA. Statements made by a person as to the cause of his death or as to any of the circumstances which resulted in his death are relevant, whether the person making them was expecting death or not. Why is it relevant? Legal maxim, nemo moratoris presumitur mentari. A man will not meet his maker with a lie in his mouth. The law presumes that a person on the brink of death will speak truthfully, without motive to lie. Conditions for relevancy of a dying declaration. Condition explanation. Death must have occurred. The person making the declaration must have died for it to be admissible. Statement must relate to cause of death. Must concern circumstances or cause of his own death, not someone else's. Declarant must be competent. The person must be in a fit mental state while making the statement. Form is flexible, can be oral, written, gesture-based, video, audio recorded, or recorded by magistrate or doctor. Not a confession. It's not the same as a confession, and Section 32 applies even when the person is not under trial. Illustration. If a woman set on fire, says, "My husband poured kerosene and lit the match," and later dies, her statement is a dying declaration and is relevant under Section 32.1. Important case laws. SNO case name citation, legal principle. 1. Pakala Narayanaswamy v. Emperor, AR 1939 PC 47. Dying declaration includes circumstances of death, not just cause. 2. Kushal Rao v. State of Bombay, AR 1958 SC 22. Dying declaration can be sole basis of conviction if truthful and voluntary. 3. Laxman v. State of Maharashtra, AR 2002 SC 2973. Medical certification of fitness of mind is not mandatory, but preferable. 4. P.V. Radhakrishna v. State of Karnataka, AR 2003 SC 2859. If dying declaration is inconsistent or suspicious, it must be corroborated. Limitations. If the declaration is doubtful, contradictory, or made in unfit condition, it loses value. If the person survives, it is not a dying declaration, but may be used as a normal statement under other provisions. Summary chart, feature, details. Legal provision, Section 32.1, Indian Evidence Act. Applicable when person has died, relevance. Cause or circumstances of own death, admissibility test, truthful, voluntary, mentally fit, form, oral, written, gesture, video, etc. Corroboration, not mandatory if reliable. Dying declarations serve as a crucial exception to the hearsay rule and help in delivering justice when the maker is no longer alive to testify. Under Section 32.1, such statements are relevant and admissible provided they relate to the cause or circumstances of the declarant's own death. Would you like this turned into a handwritten style note, flowchart? Here is a detailed, exam-oriented explanation on the relevance of dying declaration in dowry death cases under Indian law. Relevance of dying declaration in dowry death cases. Introduction. In dowry death cases, where a married woman dies under suspicious or unnatural circumstances within 7 years of marriage, the dying declaration plays a crucial role in establishing cause of death and culpability. Legal provisions involved. 1. Section 32.1, Indian Evidence Act, 1872, allows admissibility of dying declaration when the cause of death or circumstances leading to death are in question. 2. Section 304B, IPC, dowry death. If a woman dies due to burns, injury, or otherwise unnatural cause within 7 years of marriage and had faced dowry-related cruelty, the death is considered a dowry death. 3. Section 113B, Indian Evidence Act. provides for a presumption of dowry death if it is shown that woman died under abnormal circumstances within 7 years of marriage, and she was subjected to cruelty or harassment in connection with dowry soon before her death. In such cases, dying declaration becomes primary evidence to establish dowry harassment and cruelty. Importance of dying declaration in dowry death cases. Point. Explanation. Direct evidence of cruelty. Often, the woman is alone when the act occurs. Her statement may be the only direct evidence. Links accused with the act. Statement like, "My in-laws poured kerosene and set me on fire for dowry," is highly incriminating. Admissible without oath. Even if not under oath or cross-examined, it's admissible under Section 32(1), my friend. Avoids benefit of silence. Helps avoid acquittal due to lack of living testimony. Speaks to mental and physical condition, shows physical suffering, emotional pressure, and history of abuse. Important case laws. S. No, Came Citation Legal Principle. 1. Kusha Bera v. State of Orissa. AR 1987 SC 6090, dying declaration upheld conviction in a dowry burning case. 2. State of Punjab v. Gurmit Singh. AR 1996 3393, multiple dying declarations can be relied upon if consistent. 3. Laxman v. State of Maharashtra. AR 2002 SC 2973, medical certificate of mental fitness not mandatory if statement appears voluntary. 4. Vikas and Ors v. State of MP. 14 SCC 323, dying declaration can form sole basis for conviction in dowry death case. 5. Panaban v. State of Gujarat. AR 1992 SC 18117, dying declaration must be true, voluntary, and consistent. Illustration. A woman within 3 years of marriage gives a statement to a magistrate before dying from burn injuries. "My husband and mother-in-law set me on fire because I didn't bring 50,000 from my parents." This is a dying declaration that is relevant under Sec 32(1), supports presumption under Sec 130B, proves cruelty for dowry under Sec 304B IPC. Key principles from courts. Dying declaration can be sole basis for conviction in dowry death. No need for corroboration if court finds it voluntary and reliable. Can be oral, written, recorded by magistrate, or even police. Multiple dying declarations are valid if not contradictory. Summary table, legal provision, purpose. Section 32(1) IEA, admissibility of dying declaration. Section 304B IPC defines dowry death. Section 113B IEA, presumption of dowry death. Case law, validates dying declaration as sole evidence. Conclusion. Dying declarations are vital tools in the prosecution of dowry death cases, where the victim's statement is often the only voice of truth. Indian courts treat them with great weight, provided they are voluntary, consistent, and credible.